Welcome back, everyone. Today we're going to be talking about moral rights in the workplace. Okay, we're going to be talking about workers' rights, basically. What are the rights of workers in the workplace? Of course, there's going to be many kinds of rights we don't go over today, and there's going to be many specific rights we don't go over today. But we're going to give you a basic idea of the structure of moral rights in the workplace. So we're going to start with first, I should remind you your paper outline is due July 25th. Your paper outline is due July 25th. We're going to talk about the structure of moral rights, the nature of the right to work and right to work laws, and then we're going to finish with the example of the right to privacy. Okay. So in moral philosophy, what is a right? Well, a right is an entitlement. Usually, it's an entitlement to protection or to claiming something that you're owed, right? If I say, I have a right to free speech, that means I have a right to my speech being protected from certain kinds of interference, usually interference by the state and some forms of interference by my fellow citizens. To have a right to privacy, for example, is to have some claim to protected privacy. But then to have a right to fair compensation is to have some claim to be paid according to a fair or agreed upon salary, right? Okay, so we have one right to a protection and the other is a right to something. Similarly, your right to vote is a right to have the state provide you with the opportunity to vote. It's not just a right to be non-interfered in your voting, right? Okay, so we can think of them as entitlements to protection or claim rights, claims to things that you're owed, the right to vote, the right to your fair compensation, so on and so forth. The right to practice a religion is in between the two, for example. What is the significance of rights in an ethical context? Well, rights are invoked to ensure the protection of people's well-beings or the autonomy of our actions from the interference of others, right? So rights are especially important when they protect us in areas that are central to our lives or when the stakes are particularly high. As we discussed last week, work is a central part of people's lives, and so it's natural to think that workers need to have rights in place to protect their interests when they're engaged in the workplace. All right, let's start with a brief classification of rights. Now, there are three kinds of rights that we discuss in business ethics, and these rights overlap with each other. The distinction that we're going to be giving is a distinction in the nature of certain kinds of rights, okay? The first are legal rights. A legal right is an entitlement insured and protected by law, right? So we often talk about rights in the sense of legal rights, right? We say, I have a right to obtain a driver's license, okay? I passed my test. I did everything right. I have a right to obtain a driver's license. Okay, that's a legal right, right? It may or may not be also a moral right. But it is a legal right. Then there are what we call conventional rights. A conventional or contractual right is an entitlement which is ensured by a binding agreement, right? A promise you make to your friend is a conventional right. If I make a promise to you and you hold up your end of the bargain, you have a right, a claim on me to be given whatever my end of the bargain was to you, right? And then there are moral rights. A moral, or sometimes called a natural right, is a right that is just justified by moral principles. Now, these different categories can overlap with each other, right? A conventional or contractual right may be enshrined in law, and it may be morally justified. But they also might not. Sometimes we have a legal right, like the right to get a driver's license, which morality is kind of like, it's good to have driver's licenses, but we could have done it. We could have kept the roads safe another way, maybe. So maybe driver's licenses aren't in particular morally important. but some version of them are, or something like that. You can also have moral rights that are not enshrined in law and aren't grounded in convention, right? Right. But notice there can be a lot of overlap between these rights, right? You have a legal right to not be murdered and a moral right to not be murdered. Okay. The right to be compensated for your work is usually legal, conventional, and moral. That is to say, it's usually signed in a contract, protected by law, and we tend to think morally justified. But the relationship between these categories can be quite complicated. So sometimes we justify legal rights on the basis of moral rights. For example, it should be illegal to kill someone because it's morally wrong to kill someone, right? So we've got a legal right justified on the basis of a moral right or a moral claim. Sometimes we justify rights on conventional grounds. It should be illegal to sell that product because it violates our agreement. You're only supposed to sell my products in your store. You shouldn't be allowed to sell that one because we have this agreement, right? Sometimes moral rights exist because of conventional rights. For example, I have a moral obligation to not eat the leftovers because I promised you I wouldn't. I may have a moral obligation not to sell product X in my store because I promised you I would only sell your products, right? In that case, it's a moral right that's grounded in agreement. But sometimes moral rights exist independently of any agreement. I have a moral right to be free from harm, even if you didn't agree not to harm me, right? I have a moral right not to be beaten with sticks by you, even if you never agreed to not beat me with sticks. And finally, not all rights have the backing of coercive force, right? You have a right to the leftovers, previously mentioned, but the law is not going to enforce that right, right? I may have a right to the truth or to not be cheated on by my spouse or something like that. But that doesn't mean that we can make those rights enshrined in law, that we can give the government the power to enforce those rights. We don't always do that, right? So these are just some different relations that rights can have to each other. I just want you to be thinking about these things, have them in your background. What I'm trying to do is I'm trying to show you the shape and contour of the nature of rights as we think of them. Now, rights in the workplace. Obviously, many rights in the workplace are basically uncontroversial. For example, people have a right to be free from sexual harassment, discrimination, or wage theft. Most people think that we should have a right to some amount of sick time, disability accommodation, or workplace safety protections. But some are more controversial. A right to work in the first place, a right to privacy in the workplace, and a right to employee autonomy, for example. But let's take a step back before we talk about the nature and number of rights and talk about how we protect workplace rights. So our rights are only protected to the extent that there exists some mechanism or tool which enforces the protection of our rights. In the workplace, there are typically three such mechanisms. First is legal protections. These are protections of our rights ensured by the government. Those correspond roughly to the legal rights we talked about previously. Second, there are internal protections. These are protections ensured by internal arms like HR or an ethics board, right? These don't have a corollary to the rights, the classification we previously talked about. And then finally, there are unionized protections. Protections ensured through the exercise of public bargaining, using unions and unionized labor. So let's talk briefly about unionized protections, which is the most controversial of these three. Almost every workplace has some legal regulation. Almost every workplace has some HR. Not every workplace is unionized. Some argue that there's no role for unionized protections in the modern workforce. According to this view, the combination of legal protection and individualized protections, services provided by HR, ethics boards, or similar internal tools, is sufficient to provide a robust basis and protection for workers' rights. They argue that it's better for employers and employees to be able to bargain with each other directly, individually, for better deals one-on-one rather than collective bargaining between groups of employees and an employer. Further, they argue if individual bargaining is insufficient, we should use the law, not collective union bargaining, to ensure that rights are protected. As a result, we've seen an influx of anti-union legislation. So in recent years, legislators on both sides of the political aisle, though by no means not everyone on both sides of the political aisle, have sought to erode the legal rights of unions. Right-to-work legislation forbids unionized workforces from requiring dues from new workers. Now, why is right-to-work legislation regarded as bad for unions? Well, because most unionized workforces, or many unionized workforces, required that if you were to become a full-fledged member of that workforce, you become a member of the union as well. The idea is this: if the union is going to bargain for all employees' salaries and get everyone better salaries, not just the people who are in the union, then if you join the workforce without joining the union, you're going to benefit from the collective bargaining and protection of the union, even if you're not a member. This is what we call a free rider problem. The idea is that you can't have successful labor bargaining and bargaining actions if we're going to allow for so many free riders, people who don't pay their due, don't do their part, but who benefit from the actions of the union nonetheless. The union won't be successful if a majority of the workforce is expected to just ride on the coattails and ride on the advantages of having a union without doing any of the work. And then there is just straightforward anti-bargaining legislation, which forbids unionized workers from going on strike and allows unionized workers to be terminated for engaging in a strike. It should be pretty obvious how this one impacts unions, so we'll just move forward. Now, what is the role of unionized protections? Well, what do advocates for unionization say as a means for securing workers' rights? What do advocates for unionization as a means for securing workers' rights have to say on their own behalf? Well, they often begin by noting the limitations of internal and legal protections. Legal protections are important, but businesses both have influence over the law because they are able to lobby lawmakers, and they're incentivized to find ways around the law, to find loopholes, to find ways of obeying the word of the law, but going against the spirit of the law. And finally, internal protections are controlled by management. So if management is the violator of employee rights, if my rights are violated by my employer, it's not clear that internal protections can be trusted to uphold employees' interests over management's interests, right? So if my manager has committed work or wage theft against me, it's not clear that an internal investigation into that matter is going to uncover what we need it to uncover, given that internal investigators and internal operations operate at the will of management, just like the employees do. So advocates for unions will defend their legitimacy, the legitimacy of unions on the grounds that they offer the only dynamic, that is, the only one capable of answering to changes in law and employer strategy, an employee first, meaning controlled by employees, mechanism for protecting employee rights. In individual bargaining, a singular employee tries to get a better deal and to advocate for themselves to the business, to the firm, to management. The singular employee goes to the employer and asks for a raise or asks for some change in policy that will better help respect their privacy, or so on and so forth. In this arrangement, the businesses hold all the power. Advocates for unionized labor will argue that this undermines the fairness of employees who would advocate for their own rights, right? It undermines the fairness of the negotiation, not of the employee. Unionization uses the fact that employers need some workforce to engage in collective bargaining, wielding the only power that employees have over employers, that is, the product that employees give to the employer, their own labor, as the tool for bargaining. But this will only work if a sufficiently large proportion of the workforce join together to do it. Okay, I'm not sure why I did this, but the policy of at-will employment creates obstacles to all three mechanisms for preserving workers' rights. That is, not just unionized protections, but also legal and conventional approaches, right? In at-will employment contracts, the employment contract can be ended at any time, quote, at the will of either party. In an earlier in an earlier Supreme Court hearing, it was said, for example, that the contract can be ended for good cause, for no cause, or even for causes that are morally wrong. So if employment is at will, then it's impossible for any mechanism to genuinely secure a worker's rights. In at-will arrangements, I have no recourse if I'm fired for my race, gender, orientation, or creed. I have no recourse if I am harassed at work, and when I speak up against it, my employer chooses to fire me. At-will employment entails that workers' rights are impossible to be met, right? So even if you have legal protections, if there's at-will employment, that means your employer can fire you for no reason at all, right? So there'd be no way to enforce legal protections because there'd be no way to tell if a employer fired you for the wrong reasons, right? Likewise, it would be impossible to uphold any of my contractual relationships because we can't tell if our employer, there's no sense in which we can tell that an employer fired us in a way that is in violation of our pre-existing contract with the employer. And likewise, if you can be fired for absolutely no reason legally, then unionized workforces cannot engage in negotiation, in legally protected negotiations. Now, maybe unionized workforces can launch large-scale strikes, even if at-will employment is in place, and use that as a mechanism for ensuring that their rights are protected. That would be perhaps one option. Okay. But what's the alternative to at-will employment? Well, the alternative to at-will employment is due process, right? Because at-will employment makes securing workers' rights impossible, workers' rights advocates argue for a right to due process in employment decisions. Due process is the right to be protected from the arbitrary exercise of authority. If you have a right to due process, you have a right to procedures of justification over an exercise of authority. That procedure must ensure justification is met in order for decisions to be permissibly enacted. In the workplace, any exercise of authority is subject to due process: hiring, firing, approval of vacation and sick change, etc. At any point in managers' actions that affect employees have a right to a justification for that. There also should be an avenue for appeal based on whether or not those actions by management infringe on employee rights or contractual agreements and whatnot. But what does a due process right protect? Typically, it protects a right to due process is intended to protect against unjustified exercises of authority. This means that a right to due process is intended to secure protections against arbitrary firings, unjustified changes to workload or the details of a contract, and is also meant to ensure some avenue or procedure which enables people to appeal decisions and allows them to voice complaints about management. Due process rights in the workplace are meant to protect us against the arbitrary exercise of managerial authority. So far, we've been talking about classifications for rights: legal, conventional, moral, and then we went to talk about mechanisms for securing moral rights, right, in the workplace. We talked about legal protections, internal protections like HR and ethics committees, and we talked about unionization. Then we talked about at-will employment and how it violates how it renders it impossible to control workers' rights or protect workers' rights in a practical sense. Right? We said that there should be a due process right. So a due process right, as we've just said, protects against arbitrary firings, protects against the arbitrary exercise of authority. So what exactly is this thing that we've been talking about, managerial authority, and what is the basis of managerial authority? Well, in philosophy, we distinguish between two kinds of authority. First, what we call descriptive or de facto authority, which is the actual power to enact some decision. I have the de facto authority to use violent force against another person, right? I can actually do that if I went out into the world, right? Doesn't mean that I have the right to do it. Doesn't mean that I'm justified in doing it. On the other hand, there's what's called normative or legitimate authority. This is the justification to exercise the power to enact a decision. So while I may have the descriptive or de facto authority to go and punch someone, that action would be illegitimate. I don't have the normative or moral authority to go out and justifiably commit a random act of violence against a person. Now, which form of authority do those managing a business have over their business? Well, typically we think that a business has normative authority rather than merely descriptive authority. Now, they also need to have descriptive authority most of the time, but we tend to think that they have normative authority as well. So a manager is not just able to make the schedule, make agreements with vendors, hire and fire employees, but they do so legitimately. They have the authority to do so. But what is the basis of managerial legitimacy? State authority, the authority of governments, for example, is often given the basis of the consent of the governed. So what's the basis of managerial authority? That is to say, the government is ground there, its authority is grounded in this way. What is the grounds of the authority of businesses? Well, one suggestion might be that managerial authority is grounded in the fact that management has the authority to act as they wish because they own the business or because they're conferred that authority by the owner of the business, right? That is to say, we might think it's ownership which grounds managerial authority. On this view, managerial authority is like the authority to do what one wishes with one's property, to sell one's chair, to own one's chair, to sit in one's chair. I have the authority over what's done with this chair because I am the owner of it. Likewise, we might think that the owners of businesses have authority over them. That is, the right to do what one will with one's own property entails that one has authority over one's business. But notice that the right to do what one will with one's own property is not absolute. Most people think that it grounds a robust authority over one's belongings. So, for example, I have robust authority over the things that I own, but that doesn't mean I can do whatever I want with those things. I can't, for example, even if I own it, dump toxic waste in my backyard just because I feel like it, right? There might be uses of my authority over things that are regulated, right? But there's a problem with the ownership model of managerial authority, right? The main problem is this, that the model is incomplete, right? To see this, notice an ordinary limitation of one's authority over one's own property. Suppose I own a bicycle. I want to ride my bicycle home from work, but I rode the bus into work. Do I have the authority to require you to bring me my bicycle? That is, we're roommates or something. Do I have the authority to require that you bring it to me? The answer seems to be no. In order to have the authority over another person, one needs more justification than just that they own some property that the other person can, in some sense, relate to. What does this mean? It means that insofar as employees are concerned, you don't own the employee, you cannot own another person, morally speaking. So if there's to be normative authority for the managers, the authority that the managers have over their employees has to be understood, in terms other than ownership over the business. There has to be something further. So we can think of it in terms of what we might call contractualism. Another approach to the managerial authority has it that the grounds of managerial authority are just like the state's: valid consent. A manager has authority over employees because the manager has a standing and consensual agreement with the employee. A manager has authority over employees because the manager has a standing and consensual agreement with the employees. We can call that agreement the contract between manager and employee. Now, by contract, we don't necessarily mean the specific legally binding signed contract. We mean more perhaps than what is included in that. But perhaps the general ideal contract is also included in that. On this view, it's the contractual relationship between manager and employee that gives the manager authority over the employee. So why do we not mean just the actual paper contract between manager and employee? Well, we'll explain that in just a second. But for now, the idea is that the authority of the manager is the result of that authority being given by the employees to management through an agreement to work for certain goods for the manager. But there are limitations of contractual authority, right? And we can think of those limitations in terms of a contract. So managerial authority is limited by the conditions required to allow the contract to remain in good standing. That is to say, the manager has to hold up their end of the bargain. The firm has to hold up its end of the bargain to employees in order for management to maintain its authority. Some conditions of the contract are literally delineated by an actual contract, right? By paper contract, fair pay, a pay schedule, workplace etiquette policies, etc. When we're at the point of negotiating our contracts, or we're at signing our contracts in that part of negotiation, we are agreeing to these things as fair. But other conditions are merely implicit. For example, a manager does not have the authority to treat employees immorally or to force employees to act immorally, right? So those are intuitive limits on the ideal contract model we have in mind, right? There's an implicit agreement when you become an employee for a company, right? That they can't make you give up your religion. They can't make you change your sexuality. They can't make you do something that you regard as immoral. They can't treat you in an immoral way, even if that's not in the paper contract. So that also serves as a limitation for managerial authority. Conceiving of the authority of managers as grounded in an idealized contract puts forward a conception of managerial authority as reciprocal. The manager has authority to compel the employees to act and to impact the lives of employees, insofar as the employee gets the benefits they were promised as a part of their decision to join the firm. Right? It's a tit for tat. It's a reciprocal agreement. I'll give you this, the authority to do these things, to compel me to do things. You give me these things, the things that are promised in the part of us coming to our agreement. These promises include the literal contents of actual employment contracts, if there is such a contract. There's not always one. But it also includes promises that may not be so included. For example, as previously said, an employee may have only accepted a job on the assumption that there would be a certain workplace culture or an opportunity for upward mobility. If those things go away, then it seems as though the contractual model will begin to fall apart, and those people will be legitimate in leaving the workplace and no longer regarding the manager as authoritative. Now, there are many different kinds of workers' rights, and many are industry specific, but we can now provide a basic set of workers' rights by thinking about the limitations of managerial authority. As a general, though not infallible rule, individual workers' rights tend to correspond to those limitations in managerial authority. If an action from the firm would be illegitimate, that is, if the action would be one that the manager doesn't have authority to do, there's a good reason to suspect that it violates some worker's right. But how do we determine these rights? Well, as we discussed previously, many workplace rights are uncontroversial. Basically, nobody thinks that workers should be subjected to arbitrary firing, harassment, discrimination, or wage theft. Each of these things plainly violates the ideal agreement between employees and employer. But there are more difficult cases, and sometimes it can be unclear how to deal with these cases. In those cases, how do we determine whether an employee's rights are violated? Well, one way of determining whether an employee's rights are violated is to determine whether the exercise of authority on behalf of the firm is arbitrary or unjustified. Whenever someone exercises power over you, be it the employer, the state, a parent, right? You have a right to some justification with regard to that exercise of authority, a moral right, that is to say. We're talking about ethics here, right? And the idea is this. If they cannot provide a justification for you, then that exercise of authority counts as a violation of your rights. So if the exercise of authority then does not stand up to scrutiny, we can say that the act violates the employee's rights. It violates their freedoms, most generally understood. Consider a particular case, the case of workplace privacy. Most people agree that individuals have some right to privacy, though there's a disagreement about what that amounts to. Some conceptions of the right to privacy argue for a zone of privacy. Now, according to this model, the right to privacy requires that we be left alone in some aspects of our lives, that we have areas of our lives, actual zones, dimensions, spheres of our lives, where we're protected from others' prying eyes, where people aren't permitted to look without our explicit permission. On another model, the right to privacy is a right to one's information, right? Your right to privacy is the right to have certain information about your life protected from other people knowing or coming to know that information, or coming to own it, anyway. But notice that either of these models might justify similar policies. My cell phone, computer, and at-home life might be a private zone, or it might contain information which is protected from others. So practically speaking, whatever we regard the right to privacy to be, it might justify a similar kind of action in either case. There are a number of areas of life which are widely regarded as protected by a right to privacy in the workplace, right? Medical information, elective procedures, some forms of illness, for example. I may be allowed to disclose those with my employers, with fellow employees, but it may be the case that I have a right to keep those things private, at least insofar as they do not diminish my capacity for doing my job. But there's also private information, my hobbies, my clubs, my political affiliations. I should be permitted in the workplace to keep those things private, again, insofar as it doesn't impact my performance in my job or the company. Further, familial information, who I'm dating, who I'm married to, when I'm getting married, whether a family member has died, etc., are the kinds of information that we tend to think I have a right to privacy about. If an employee chooses to have these things remain private, then employers have an obligation not to try and find out this information about them. If they do, it's a violation of the right to privacy. This is generally accepted or a less controversial set of privacy rights in the workplace. And most importantly, they're forbidden from making decisions on the basis of the information that I have a right to privacy regarding, right? You can't choose to do something to me because of something that I have a right for you not to know in the first place, but you happen to know through means that I had no control over or whatnot. But since the 2010s, new issues around workplace privacy have arisen as the digital age has become more profligate and a part of the workforce. With the advent of social media, smartphones, and digital technology in the workplace, the limits of employee privacy have been tested. There are many questions we can ask about digital workplace privacy. Should employers be permitted to make hiring and firing decisions on the basis of public social media? Should employers be permitted to track the activity of their employees at work? Should employers have access to an employee email, even if it was sent privately to another employee, etc.? But let's focus on one of those questions, the bossware question. Should employers be permitted to monitor the activity of their workers that are using the business's technology during working hours? So these are workers who are using company laptops or company cell phones during the working hours. So bossware is software installed on a digital device which allows remote access to management and which reports information on employee activity to the firm. Proponents of bossware give a number of reasons in its favor. Bossware allows managers to promote productivity, reducing wasted time on social media and similar uses of digital technology. Since managers already have the authority to promote productivity in the workplace, this is not new. This is just a part of that. Bossware allows management to make sure that workers are not using company property to do things that are inappropriate for the workplace. That is, not just things that are unproductive, but positively inappropriate, like viewing pornography or sending death threats to congressmen. And further, in cases where a company owns the workplace technology, the laptops, cell phones, etc., the claim is they should have a right to monitor what's happening on their property. But there are also just as many claims against bossware. For example, bossware violates the privacy of employees, according to critics of bossware. Some communications between employees or between different employees or between employees and HR may be critical of management, and employees should be safe from retaliation from management for their criticisms. Further, bossware creates a culture of distrust between employees and management, undermining employee morale and commitment to the firm. Being monitored, being put under surveillance, seems to have that effect, the claim is. And finally, employee productivity should not be micromanaged, but should be outcome-based. If employees accomplish tasks on time, with high quality, they should be permitted to do as they wish in the downtime between tasks. This may even help reduce burnout and the like. So, for this week, I want you to think about the question of bossware for your discussion post. I want you to think, is there a good enough justification on behalf of management, on behalf of the firm, to have bossware installed on devices that employees are working on during working hours? So the questions I want you to answer are, do you think that bossware should be allowed on the company technology? Why or why not? Further, if employees use their own technology for work, should management be permitted to require employees install that bossware on their private computers and phones? And finally, can you think of any arguments other than the ones listed in favor of or against bossware? That's all I have for you this week. For next week, read what I have listed in the syllabus. Have a good week. Thank you all. Goodbye.